Good afternoon, everybody on the East Coast, and good morning to all my fellow West Coasters out there. The special compliance webinar on the new FCC rules and amendments. With me, as usual, I've got my sidekick here, Joe Sansgrant.
Hello, everybody.
Got a lot of people still trying to join, but we're just going to go ahead and jump into the content because we're kind of crunch for time. And there's quite a bit to cover with the new rules that the FCC put out last week. They put out a press release. They kind of prefaced what we thought the rules were going to be, and then they put the rules out, and the rules actually were a little bit different. So there's been a lot of confusion in the industry about what exactly the FCC is doing with pre-recorded message and calls to cell phones. We've got our contact information that's going to show up here. So if there's something we don't cover today, and you've got questions, feel free to reach out to myself or Joe. We should have some time for QA at the end of this call. And we've also got a list of the products that we provide that can help with some of the requirements around scrubbing for cell phones, for do not call records, as well as getting updates. You know, we already went ahead and wrote a white paper about some of these rules and put it in our compliance guide, so got that product available for people that are not using it. I know a lot of people already are. So let's get into the agenda for today. Just kind of, these are some of the questions that I've been getting here, which has been quite a bit. I'd say out of the changes that have happened in the last 2 or 3 years, this one in particular has spawned a lot of questions from people trying to figure out what they need to do with their website, with their privacy policies, to what they'll need to do with their collections calls. So we're going to try to break it down in terms of what's going to apply to your organization, for the different industries that are out there. We're going to talk about the types of dialers that are going to be affected and what the FCC defined as a dialer. We'll talk about campaigns and call abandonment, pre-recorded messages, wireless calls into text, what the FCC, the big game changer is there. We're also going to talk about what you need to scrub, plain and simple. And we're also going to talk about a very important part of this rule, which is the implementation guidelines, when you actually need to comply, because it's not all of it's right away. So there's some staging in of this information. So with that agenda out there, and we do have the call recorded, or we're recording the call, and so we'll get out a link to people if you don't have folks that are able to join today. So it's kind of short notice. We're getting the webinar together, try to address the questions in kind of a live format. But we've also got a copy of the slides that people can look at. And we're probably going to, I would say not even probably, we are going to replay this webinar in a separate live session next week, probably towards the end of the week, so that people that couldn't join and a lot of your colleagues or people that you might want to get this information can participate. Let me get over to the next slide. Joe, you want to give us the background on what the scoop is on everything here?
Sure, absolutely, and thank you, Ryan, for the opportunity to be here today. Before I even start, I just want to say that this area of pre-recorded calling, as it impacts predictive dialer calls to cell phones and residential lines, and it's a very confusing area of law. And why is it so confusing? Fundamentally because the FTC and the FCC have just different approaches as to how they regulate this area. And the reason that the FTC and the FCC have different approaches is that their hands are tied to a certain extent. They are regulatory agencies that have been tasked by the executive branch of our government and to do certain things, and they have to implement their rules and regulations in accordance with what they are told to do by the United States Congress. So they understand the issues that are out there, but the rules and regulations that they issue have to be tied to the specific language that they have been given under various enacting legislation from Congress. So that's the reason why it's complex. And just a little bit more on background, this goes back to 2008 when the FTC decided to change its pre-recorded rules. And the fundamental perspective here that the FTC wanted to take was, all right, well, we have people out there that are doing telemarketing. They're sending off pre-recorded messages to people. Based upon the feedback that we have been getting from consumers, what are we going to do with it? The FTC said, we're just going to say that any pre-recorded message of a telemarketing variety has to have express written consent. So across the board, anybody out there sending off pre-recorded messages for a telemarketing purpose or for something that leads to a telemarketing transaction of some sort, you have to get express written consent. And then even beyond that, the FTC decided to require, it took a look at the technology, the state of technology, telephony technology out there, and said, you know what, if you're going to send off a pre-recorded message under our rules, you have to include either an automated key press or a voice-activated mechanism to do it. And the FTC rule, I like to say that it's technology agnostic. It doesn't matter how you make the call, whether it's a manual or a predictive dialer call. It doesn't matter to the FTC, and it also doesn't matter if you're sending it off to a landline or to a wireless number. And that's a good thing because it makes things simpler in terms of understanding what the rule says. The problem is the FTC doesn't regulate everybody. There are big areas of industry, common carriers, financial institutions, and insurance companies that are just not regulated by the Federal Trade Commission. And so very often, whenever there's something involving telemarketing, the FTC and the FCC have to coordinate a little bit. The last point is that the FTC decided to move away from its per day, per campaign standard, which was a good thing, and it went with a successive 30-day per campaign standard for measuring call abandonment. And by successive, I mean it's not on a rolling basis, just every 30 days from the get-go, from the start day of your campaign, you stop, you measure your abandonment rate for that 30-day period, and then you restart the clock at day one again. Okay, so flash forward a little bit to January of 2010, the FCC issued a notice of proposed rulemaking, and wherein it said, okay, well, we have these different rules, and there's conflict between what the FTC has in place and what the FCC has in place. Now, of course, the FCC has to work within their legal framework, their legislative framework, so their rules are not going to be technology agnostic. You know, it would be extremely helpful if Congress were to just weigh in and change the underlying legislation, because that would allow the FCC to create rules that were technology agnostic. But anyway, this is what we're stuck with. And the FCC didn't address the rolling versus successive abandonment measurement idea in this notice of proposed rulemaking. And at the time, I put out an article via the Contact Center Compliance newsletter that really said, you know, it would have been nice if the FCC had addressed the rolling versus successive issue. So that is some background, and let's move right into the report and order that just came out. Ryan, let's go to the next slide. And just as a notice to everybody on the call right now, I have 5 children in my house. 3 of them are mine. 2 of them I'm not sure where they came from. And I fully anticipate at some point during this phone call there will be an interruption. So, you know, just to keep everybody advised. Issue 1, predictive dialer calls, and I've shortened it up to PDPR calls to cell phone. This is the #1 issue for the industry. It's a very important issue for the industry because of the prevalence of the use of predictive dialers and the prevalence of the use of cell phones. Over time, certainly over the past 5 years, we have seen a rapid increase in the number of cell phones that people make use of, and we've seen many people just decide to switch away completely, get rid of their landline entirely, and just go to a cell phone service. And over time, everyone anticipates that is just going to increase the number of people that do that, and that, of course, impacts the industry.
Joe, I was just going to add I just pulled the stats the other day in terms of people that have converted over from landline. And according to the CTIA, as of June 2011, so this data is probably about 6 months old, this is when they put out their report, the number is 31% of the U.S. is a wireless-only household.
Wow.
So that's probably like 35% now.
Right. So, of course, it's very important. So, under the new rule that the FCC, well, first the old rule was that you can't make a predictive dial, pre-recorded call to a cell phone without prior express consent. And I just threw in PDQ because I'm using all of these abbreviations. And I like to think that I'm funny and clever that way, but I digress. So the old rule is no such calls to cell phones unless you have prior express consent. Of course, we have the FTC that had weighed in with regard to pre-recorded calls. And so the FCC said, well, we have to update our rules. And so it's now created 2 categories. Category 1, telemarketing, predictive dial, pre-recorded calls to cell phones. And then Category 2, all other such calls to cell phones. And the Category 1 calls and by the way, this is my language. The FCC does not refer to Category 1 or Category 2 calls. This is me parsing out the report and order and the new language. The FCC divides Category 1 into 3 subcategories. Calls that constitute telemarketing generally, and this is what most people on this call are concerned about. We need to get prior express written consent. So if you're making telemarketing phone calls and you are calling cell phones and you're using a predictive dialer, you need to get prior express written consent. And the same thing applies if you are sending off pre-recorded messages, but that's really no surprise. The big surprise is that because of the structural way that the FCC has been tasked with regulating this environment, they felt at least that their hands were tied, and they had to take the same prior express written consent that's required in the context of pre-recorded calls and apply it in the context of predictive dialer calls to cell phones. The next subcategory here is telemarketing calls that are made by tax-exempt nonprofit organizations. You still only have to get prior express consent if you are making a call to a cell phone. And then finally, calls that are related to HIPAA, and for that, they're actually exempt from the rule, and we don't need to really address that. If anybody has questions with regard to the HIPAA calls, feel free to contact me. You can call my office at 212-626-6934 or email me at jws@sansgrant.com. The Category 2 calls, the second category, I just call a catch-all, and these are all predictive dialer pre-recorded calls to cell phones other than the ones that are delineated above. And for these, you just have to get prior express consent. And these are informational, non-telemarketing calls. And the FCC really went into great detail to describe what it means by informational or non-telemarketing calls. And the FCC includes in this category research or survey messages, nonprofit fundraising messages, informational calls by school boards, political candidates, airline notification services, bank account fraud services, and debt collectors. And I know that this is an important area for Ryan. There are a lot of debt collectors out there that rely on their ability to contact people on their cell phones. And the good news for the debt collection industry is that, okay, you don't have to get prior express written consent. We're still dealing with the same framework of prior express consent, and that's good. And we're still dealing with the same framework where the FCC has ruled that if you're making a predictive dialer call to a wireless number, and that wireless number was provided to you, provided by the called party in connection with an existing debt, then it's implied that prior express consent exists for that call. So essentially, nothing has changed for debt collectors using predictive dialers calling cell phones, but the fact remains that if you have a cell phone number that was not provided to you in connection with the existing debt, then you still have to scrub out those numbers because you do not have prior express consent for those phone calls. So I think that takes care of category 2. So Ryan, let's move on to the next slide.
Joe, do you want to talk about how preview dialers fit into this mix? I mean, that preview dialer kind of falls, according to the FCC, really falls under the same category as a predictive dialer per their definition of a dialer, if I remember right.
Well, yeah, do I want to delve into that right now? Not particularly, but you know, I've come down on the side, and Ryan, we tend to disagree on this. I've come down on the side of, you know, and every company has to make their own determinations here. But the question is, if you're doing preview dialing, if the number is coming up on a screen and somebody has to press a keyboard button in order for that phone call to be made, does that phone call fit within the predictive dialer environment? And reasonable minds can differ on that question. I advise my clients that I consider that to be a manually dialed call. And I've written at least one article on this that Contact Center Compliance has published in their newsletter. That generated a good deal of comments, and people come down differently on this issue. I think ultimately it's a question of risk aversion. If your company is just absolutely risk averse and you want to make sure that you really never have to confront any issues related to this, and you're doing preview dialing, throw that preview dialing, all those preview dialing calls into the category of a predictive dialer. If, however, you're a little bit less risk averse, then you very well may want to consider such calls to be nulls. Ryan, do you have anything to add to that? Not that there is anything to add to that, because I have just completely preempted the entire field of discussion, but, you know, feel free.
Yeah, I mean, I've heard it, that differing opinions, you know, where
my
preview dial, yeah, I mean, a lot of people like your opinion because it puts, I mean, if you're looking at how you're going to call a cell phone and you go to a regular fat finger POTS line dial, it's just not very effective in terms of being able to dial out numbers. It's also not easy to control from a compliance standpoint because now you've got data that's off a system of record a lot of times. So a lot of people like your definition, but then other people hear other opinions and get confused and go, well, it has this language about the capacity to make automated phone calls and storing sequential numbers and that kind of thing. So people get a little nervous about that. But, I mean, you and I have talked about this before, and if you look at, you know, the FCC's enforcement record, they have not enforced that part of the rule, to my understanding, as far as somebody.
Exactly. Yeah. It's just never come up. And you know, Ryan, you raised another issue here, and I'm just going to say it. Going back before 2008, before all of this started, at one point the FCC decided to take its definition of an automated telephone dialing call and say, oh, well, obviously Congress was referring to a predictive dialer. In my humble opinion, Congress was not referring to a predictive dialer. It was referring to a machine that dialed either sequentially or randomly. And no one has ever taken the FCC to task for that ruling. And I think it's, you know, maybe with this latest round of rules that require prior express written consent if you're making a telemarketing call to a cell phone, Maybe if the FCC decides to enforce it, some company out there would decide to say, you know what, the entire underlying justification for going after predictive dialers here is wrong, and I'd be more than happy to help out any company that decided to take on the FCC on that issue. So yeah, I went there, Ryan.
You've been down that road.
Okay. Issue 2. I sound like that guy on the Sunday morning talk show. But anyway, pre-recorded calls to residential lines. Under the old rule, you had to have prior express consent if you wanted to deliver a pre-recorded telemarketing call to a residential line, unless you had an established business relationship, and under that circumstance, you did not have to have prior express consent. The FTC had a similar rule in place, and that was removed in August of 2008. And at that point, moving forward, under the FTC rules, you had to get express written consent, whether you have EBR or don't have EBR, in order to deliver a pre-recorded telemarketing call to a residential line. Under the new rule, and this is actually an example of the FCC just following what the FTC has in place, and that's good news to the extent that it provides consistency for the industry. Under the new rule, you can't rely on an established business relationship if you are delivering a pre-recorded telemarketing call to a residential line. You have to obtain express written consent for any such call. Again, the FCC goes out of its way to say that this only applies to telemarketing calls and not informational and non-telemarketing calls. And also, this new rule does not apply to calls that are regulated under HIPAA. So this is pretty straightforward. I'm going to say the majority of the people on this phone call right now are regulated by the FTC and are most certainly not making pre-recorded telemarketing calls to residential lines in the absence of express written consent. The only real change here is that for those industry verticals that are not regulated by the Federal Trade Commission, you now no longer have the option of saying, well, we're in a different jurisdiction, we don't have to follow that FTC rule. Now the FCC and the FTC agree on this issue. So moving on to issue number 3, which is the abandoned call changes. The old rule that the FCC had in place was that you measure the abandonment rate every 30 days across all calling campaigns. And that's a good rule. I like that because it allows you to have a bunch of different campaigns, some big, some small. You combine them all together, and you come up with an abandonment rate that works. The problem is the FTC requires measurement on a 30-day successive day basis per campaign. That in and of itself, switching to a 30-day basis, that was very good news because the FTC used to require per day per campaign. But it's too bad that now with a new rule from the FCC, for those entities that are regulated just by the FCC, you can't combine across all of your different calling campaigns. So anyway, the new rule is almost the same as the FTC. You measure your abandonment rate every 30 days per campaign, and it's on a successive basis. It's not a rolling basis as the FCC used to have. It's just every 30 days, and the starting point is the first day of the campaign and every 30 days thereafter. And the only difference is that the seller has to disclose that the call was for telemarketing purposes along with the name and telephone number of the seller. So as you're preparing your abandoned call message, if you are not regulated by the FTC and you are regulated by the FCC, or actually if you're regulated by both, you have to include in your abandoned call message that the call was for telemarketing purposes. The FCC puts this phrase, these two words, in as you can see, in quotation marks. And so it's, most people look at that and say, well, I guess we'll just say that the call was for telemarketing purposes. But at the same time, perhaps there's some leeway there as long as you are, in the course of the abandoned call message, letting the person know that the call was for telemarketing purposes. You perhaps do not have to use those specific words. Okay, let's go to issue 4. Automated opt-outs. What rights and powers are you required to give people to assert a do not call request during, first of all, an allowed pre-recorded message under these rules, and secondly, and this is kind of regrettable, but secondly, in the abandoned call message itself. The FCC rule on this point is that pre-recorded telemarketing calls that, and this is a quote from the TSR, that could be answered by a person must have an interactive voice or key press opt-out. And then pre-recorded telemarketing calls that could be answered by an answering machine require a disclosure of a toll-free number. And, you know, I'm emphasizing the could be answered part because, you know, it's impossible to tell at the instant right before the phone call is picked up whether it's going to be answered by a person or whether it's going to be answered by an answering machine. And so if you are looking at that and you want to comply with the rules, you know, the black and white rules that have been issued by the FCC, in your pre-recorded message, you're going to have to include both the potential for an interactive voice or key press opt-out and the disclosure of a toll-free number that people can call in order to assert a do not call request. And with the FCC new rule that comes out, there's good news and bad news. The bad news is that the FCC requires the delivery of an opt-out during the abandoned call message. This is a big difference between the FTC and the FCC. I don't know why they can't seem to get together on this one. I don't see any underlying legislative rationale that the FCC requires this during the opt-out, requires the opt-out during an abandoned call message when the FCC does not require that, but that's where things stand right now. And then the toll-free number disclosure has to be made during a pre-recorded telemarketing call or a message that is, in fact, left on an answering machine. So there's none of that problematic could be answered language. So it's very clear if you are just regulated by the FCC, you can send off a pre-recorded message, and if it's in fact left on an answering machine and you're doing answering machine detection, you can set it up so that you just put in the toll-free number disclosure, and for those calls that are in fact answered by a live person, you have the interactive voice or key press opt-out. In practice, I'm not sure how this plays out. I'm not sure exactly how companies are complying with the FTC rule, but this just adds an additional wrinkle because there's lots and lots of, the majority of entities out there are in fact covered by the FCC. And so this just adds some wrinkles in how we're handling abandoned calls and opt-outs in the context of pre-recorded telemarketing calls. So moving on to the next slide, and I will take a drink of water. Thank you very much. Implementation, key issue, because this lets telemarketers know how long they have in order to comply with these new rules. The starting point is the publication in the Federal Register of the Office of Management and Budget's approval of these new regulations that have been issued by the FCC. Now, I'm not sure exactly why. I haven't even looked into the issue of why the start point is the publication of the OMB's approval. I don't really care. I'm just going to be looking at the Federal Register probably, every day or so to check when this approval is actually published in the Federal Register. Apparently it has something to do with Paperwork Reduction Act, but that's just how it is. So that's our starting point, and Ryan and I will, of course, be doing our best to monitor that so that the industry knows when the start point is. And the FCC has established 4 different categories for implementation. First of all, there's a 30-day period to implement the new abandoned call rule. There's a 90-day period to implement the opt-out mechanism for pre-recorded telemarketing calls and abandoned call messages, as we just discussed. There is a 12-month period for phasing out the established business relationship exemption for pre-recorded telemarketing calls to residential lines, and then finally a 12-month period for implementing the rule that prior express consent has to be in writing for predictive dialer calls that are made to cell phones. So for a lot of entities, this generated, as Ryan said, a lot of confusion, a lot of questions. And I believe the reason for the confusion and the questions is that underlying dissonance between the FTC and the FCC's rules. And a lot of people were very concerned about this, but bottom line, we're still not even at the start point for the implementation deadlines. For the abandoned call rule, I don't think it's going to be too difficult to implement what the FCC has in place. Same thing for opt-out. I think anyone out there who's sending pre-recorded telemarketing calls to people, they already have an opt-out mechanism in place. And then, for the last 2, we have a full year in order to figure out how to comply with these new rules, so that's plenty of time to handle that. And I say that confidently because as a lawyer, I'm not doing telemarketing. I guess I personally don't need to worry about it, but of course my clients need to worry about it. But 12 months is certainly a great amount of time in order to ensure that you're complying with these new FCC rules.
Hey, Joe, what are the potential fines for, let's say, we're beyond the 12-month period with the cell phone rule for predictive dialing?
Right. Well, the main source for fines that has played out under the FCC rules is the private right of action that people have. That they can take you to small claims court and say, all right, I've received X number of phone calls that are in violation of the FCC rules, and they can hit you with $500 per violation and up to $1,500 for knowing and willful violations of the FCC rules. But then, the FCC has its own enforcement mechanism, and I believe it's, similar, like with the FTC, I think it's up to $16,000 per violation on the FTC side, and for the FCC to have its own enforcement mechanism against you, I think it's $10,000 per violation.
So the FCC gives you they allow a private right of action where the FTC, like if you call a do not call number, that's not considered a private right of action.
Right, exactly. All of the individuals out there who started their own little businesses going after companies that violated do not call and other rules, they're relying on the FCC's private right of action. And again, probably a good number of people who are on the phone right now have received those letters saying, you called me in violation of do not call law, but we can settle this and everybody go home for $500, that sort of thing. And that is all generated under the private right of action that the FCC has in place.
One of my clients told me last week that they don't call the city of Ann Arbor, Michigan, because the University of Michigan Law School, some professor gives their students extra credit if they go out and sue a telemarketer.
How about that?
Thought it was an interesting
yeah. Well, anyway, that's a way for new lawyers to get a little bit of experience in the small claims court environment. All right. Now, do we have, is there a slide after this? No. There's issue 5.
Issue 5, there's no issue 6, so we must be into the questions.
All right.
A few of them come in. And,
I don't see why, because I've outlined everything to perfection.
Yeah, I know. We can all go home now. We answered all your problems. See you next year. We had a few. So if you want to ask some, feel free to put them into the little text box and go to meeting, and I'll see them and I'll relay them over here to Joe. First one is, does the requirement that the outbound abandoned call recording contain an opt-out mechanism mean the mechanism must be 1, voice activated, or 2, key press activated, or both?
Oh, yeah, it's an option if that's what the question is. It doesn't have to be both. You can choose to either do a voice activated or key press. It's up to you how you want to handle it.
So there's your answer. It's your option. Somebody wanted us to have Joe explain if the question between PD/PR means and, or if it means or. This must be up in the slide deck.
Right. Yeah. It means and.
Okay.
So whatever I'm talking about, I'm talking about predictive dialer calls to cell phones, and I'm talking about pre-recorded calls to cell phones.
Okay.
And again, that's how the FCC has to address the issue under the enabling statute that gave it the authority to implement these regulations.
Cool. We got that one covered. We talked about, a couple of people had questions about the dates that these take effect. We only know, based on when the registry is published, and then we'll follow it from there. If a PD is not used, can cell phones be called without express consent? An example would be customer established an account with the company and provided the cell phone number as the contact on the account, meaning can you still manually dial cell phones?
Yep, and the answer is yes. That carve-out, that exemption is still in place. The new FCC rules only govern when it comes to making calls to cell phones. And as a telemarketer, what do you need to worry about? We're talking about predictive dialer calls to cell phones, and there's just nothing on the books with regard to manually dialing telemarketing calls to cell phones. Now, of course, you still need to worry about do not call, but you don't have this additional worry about prior express written consent.
But you would need to be worried about I call them the 5 wireless do not call states.
Oh, sure.
There's 5 states: Texas, New Jersey, Arizona, Louisiana, and all 5 people in Wyoming. Those states,
which is disparage our good friends in Wyoming.
Of course not. But yeah, those states have extra rules on calling any consumer in that state for telemarketing purposes, regardless if you're using a predictive or making a manual call.
Right.
So
yeah, from a general standpoint, if you want to protect people in some manner from receiving telemarketing calls on their cell phone, does it really matter if the call is made manually or if it's made with a predictive dialer? The answer is no. But because of the way that the underlying statute is written, and because of the determination by the FCC that an automated telephone dialing system includes a predictive dialer, this is what we have.
Yeah, like when we do a wireless scrub, we give back, for our collections customers or somebody that's just filtering wireless numbers with us, we provide back a match on the landlines, and we provide what I call them your clean wireless numbers, and then there's a kind of a subset of do not call that matches against these state issues. The 5 states that would fall into that. Here's another one. Does the disclosure require a toll-free number, or can it be a regular phone number, meaning a non-toll-free? That's what mean about the opt-out requirement.
Right, exactly. And yes, it does require a toll-free number.
It does require toll-free.
Yes.
That is good to know. You're going to open up a toll-free business.
All right. We'll do that, Ryan.
Cool. Miss my days in the telecom business. When getting express consent to call a cell phone, must the opt-in language confirm that the consumer is providing a cell phone and that the consent is being given to call from an auto dialer?
Well, and you know, that really, of course, that's kind of the key issue here. You know, now that we accept the idea that we have to have prior express written consent to make a telemarketing call to a cell phone, how exactly do we go about doing that? And guess what? There's really no one answer with regard to that. And that's why it is always helpful to seek out advice of counsel with regard specifically to questions like that. I'm sure there's you know, any number of good attorneys out there who can help the questioner with that issue, including Michelle Schuster and Mitch Roth and myself. And but that, you know, in the context of this telephone call, it's very difficult to answer that question because a lot of things have to be taken into account. You know, the type of campaign that's being conducted, but then also, you know, the relative risk aversion nature of the entity that's making the call. And so that goes under the category of consult with your attorney.
I'll go with that.
It's an answer without an answer.
Here's one from another attorney that I know that's on the phone. How do the new FCC rules affect business-to-business calls?
Generally speaking, they do not affect business-to-business calls. If you parse out the language of the FCC rules, you'll see that in the majority of instances the rules do not apply to B2B. There are some areas where arguably it does apply in the B2B context. But in various conversations that I and other attorneys have had with people at the FCC, even with those areas where one could, you know, make the case that the language applies to B2B, the FCC has no intention of applying that in the B2B environment. There is, you know, some language where it is express, where it expressly makes it clear that it applies to B2B. You know, there's some language in there about how you're not supposed to use an automated dialer to engage multiple business lines if you're making a phone call to a business. But generally speaking, the rules do not apply in the B2B context.
That's a good summary because we've been getting that question from a couple of people and from some of our clients here. Here's another question. This is pretty timely given the amount of political calling going on right now. The question is, third-party telemarketing firm making political calls for a candidate, are they exempt from FCC rules or not?
I would just say exempt. The FCC went out of its way to make it clear that calls that are not for telemarketing purposes, and that would be political survey calls, polling calls, fundraising calls, would not be impacted by these new rules. They're just not covered by the FCC's jurisdiction.
There's another question here. It says, paragraph 2 of the report and order introduction states that we revise our rules to require express written consent for all auto dialer pre-recorded telemarketing calls to wireless numbers and residential lines. The rules contradict this statement by not requiring written consent for auto dial telemarketing calls. Do you think the FCC will address this contradiction to clarify their intention?
All right, and just I just want to clarify. I just want to flesh out what I just said before. there's still a thing of, if you're using a predictive dialer to make the political calls, I mean, there are plenty of robocalls that get sent out. You still have to worry about calling cell phones. And that's, under the FCC rules that say that if you're using a predictive dialer to call a cell phone, you have to have express consent. So even in the context of a political call to a cell phone number, if it's made by a predictive dialer or an auto dialer of some sort, you would still be well advised to scrub out numbers that are cell phone numbers. All right, and so Ryan, you want to ask that question again?
Yeah. Basically, they're saying that the report and orders rules contradict the statement by not requiring written consent for auto dialer telemarketing calls. So they seem to think that there's a contradiction between some of the statements there.
Yeah, there is contradiction between the language in the report and order and the language of the rule itself. And fundamentally, just go with the language in the rule and comply with that. Whoever drafted the report and order perhaps was a little more inclusionary in some of their language as to how far some of these rules apply. But the place where you go to understand what rules apply to you is to look at the new rules and apply them to your organization and to your calling campaign.
Yeah, and that's kind of, I think, what a lot of the media picked up was the stuff in the report and order and the press release that was a lot broader than was actually in the rules.
Exactly, and this is already a confusing area to begin with, and it's regrettable that that the language appeared in the report and order that way. I'm not sure if there's an amendment process for the FCC to make a change to a report and order, but I would bet that at some point, if it hasn't already, the FCC has been apprised of the discrepancy between some of the language in the report and order and the actual rule itself. But
yeah, you even had some FCC officials making statements that were not in the actual rule. So
yeah, let's just focus on the rule and deal with that. And anything else beyond that, of course, it's going to cause some confusion out there. But hopefully that's what we're addressing here today.
So, yeah, there was another question about that we had mentioned about how does this affect what type of dialer we can use in our agenda, and we didn't really kind of cover that. I mean,
well, when we're talking about type of dialer, you essentially have three categories. You have predictive dialer, you have manual dialing, and you have preview dialing. All right, I guess you have another category, just all-out auto dialing, which generated by sequential number generation or randomly. But I just don't get the sense that there's anybody out there doing that anymore. So yeah, we have these three categories, and we still have that existing manual dialing exemption that we discussed. We do have the preview dialing issue that we discussed, and then it's clear cut that when you're dealing with predictive dialers, you absolutely have to comply with these new rules that according to the FCC at least, its rules apply to predictive dialers because the FCC has concluded that a predictive dialer is an automated telephone dialing system.
Let me ask, what type of EBR do we need to have to manually call cell phones?
What type of what?
EBR, established business relationship.
There's no requirement there. It's just it's an area that is not addressed under FCC's rules. The FCC was tasked with regulating automated telephone dialing calls to emergency lines, to hospital lines, and to wireless devices. And so that is what the FCC is doing here. The rules that we're discussing here just do not impact manually dialed calls to cell phones.
I'll take the next question. The question was about the 5 states with the cell phone rules. If you have an EBR, you can manually dial. You really have to look at the rule itself. Most of those states, you actually have to have something more along the lines of a permission EBR rather than an inquiry or just the fact that you're a customer to solicit that cell phone number. It's efficient button. Joe considers pushing a button to connect to a telemarketing sales call manually dialing. Joe considers. I'm not sure what that, if that's a question
kind of
or more of a comment.
It sounds like a statement. It sounds like, just confirm. And yeah, I will confirm. And there was an article that I published where I kind of went through my rationale for making that determination. I guess a better way to say it is that there is sufficient language available in various FCC pronouncements to reach the conclusion that preview dialing, where there is a human element, human interaction prior to the placing of that call, that would then take it out of the category of automated dialing and put it into the category of manual dialing.
Here's a good one from a fellow compliance officer. If you're not sending pre-recorded telemarketing calls and you're just using a predictive dialer for telemarketing calls, however, a live operator is not available within 2 seconds, so the abandoned call message must be played, does the abandoned message have to include the opt-out mechanism?
Yeah, it sure sounds that way. Absolutely.
So
that's what the language in the rule says. The opt-out mechanism applies not only to a pre-recorded telemarketing call delivered to a residential line, but it also applies in the context of the abandoned call message as well. And I realize that's kind of surprising. I was just as surprised as everybody else when I was going through it, and I kind of had to double check and triple check the language to see if that's the way that the language reads. But yes, that's exactly the way the language reads.
Another question about how long you need to keep your compliance record per the new rules. Is there anything in there that establishes new guidelines, or does that go back to other kind of safe harbor or best practices?
It just goes. There's nothing specific in the new rule where they said, for this new rule, you have to keep records for this amount of time. Generally speaking, I advise people to keep records for 2 years, and that 2-year period is laid out by the FTC, and generally just across the board. I think 2 years is a sufficient period of time to maintain such records. All right, Ryan, now I need to take off, if that's okay with you.
Yeah, I think that's good. I think the only thing that we didn't talk about was on the consent side. You would be able to use the things that qualify under the e-Sign Act for electronically authorizing electronic consent, but I think the important thing to remember is that the burden of proof that these people opted in and you got their express consent is going to be on the company that you work for. So,
right. And a key point is when you're dealing with a signature, under the e-Sign Act, how far can you take it? I believe that you can take it to a recorded conversation. That is, a recorded conversation can act as a signature if it's handled in the right way, and if the key thing is the person intending for a signature to be taking place. And that can be kind of tricky to achieve in the context of a telephone conversation, but I believe it can be done.
Cool. Well, Joe, thank you very much. Appreciate your input today. Again, we're going to try to put on another session next week for people that weren't able to attend. We'll get the slides out along with the link to the recording. The report in order itself is something a couple of people asked for. It's pretty easy to find to the FCC site. Maybe what I'll do is just put a link to it in the follow-up email so that people have a way to get to it. You can actually also watch the hearing about this on their webcast. It's not that terribly long, but you can hear the votes on it and what their interpretation is. I mean, they're very much trying to stem the large amount of complaints they're getting about pre-recorded calls. And if you're not gearing up to scrub cell phones, or if you need some help with that, that's our core business. We do both the ported and the carrier scrubbing. And we're all out of time, so appreciate all the questions today. That was very helpful. So look forward to maybe seeing some of you folks online, and we'll go from there.
And at the upcoming ATA convention in April.
That's right. It's a very nice venue in South Florida. ATA's got some new leadership, and looks like it's just going to be a really exciting event. I think Joe and I may have landed a speaking gig. We're waiting on pins and needles, so hopefully we'll get that dialed in, so we'll be able to put on another show down there.
Beautiful. All right.
Good.
Well, thank you, Ryan. Thank you, everybody, for joining us today.
Have a great day. Thank you.